Hi, this is Professor Chad McGuire, and this is our last video lecture in the introductory series, a series of 3 lectures introducing the overview and concept of environmental law, whether or not environmental law is necessary, what are the sources of environmental law, and now finally here today, now the finding of the law in environmental law in the United States. So we have reviewed some of the policies that drive the creation of environmental law in the overview portion of the introduction. So we have an understanding that environmental law is really the output or the result or the conclusion of policy directions related to the environment. So in general, we have an issue that it arises in a number of ways. Most of the history of environmental law in the United States has been reactionary, which means that in the traditional policy parlance, there has been a problem that's presented itself. So just to use the simple examples, whether it be clean air or clean water, the water has become problematic, it's become dirty. The air has become dirty because of human actions. And as a result of that, as a result of noticing that, these events, whether it's the smog in Los Angeles or some of the tragedies like the Cuyahoga River in Ohio catching fire or some other things, they have brought to the public's attention, generally speaking, and therefore the governance structures, the political structures, has brought to the attention the need for some sort of action different from what we are doing, whether that be just allowing laissez-faire market forces, that kind of thing. So the notion that government needs to intervene, but it's reactive. Those 2 examples are reactive in nature. And so those events trigger a focusing moment or a focusing event. And that focusing event allows for sort of, if you use, again, in policy parlance, say the issue attention cycle. Now there's an issue that's been created. Oh no, we have a problem. We have some air that's dangerous. It's not good for humans. We have water that's dangerous, not good for humans. And so we need to do something about this. And then we develop a policy. And then that policy results in some law, usually that law being the formalization of policy. If we think of the policy-making process, legitimating policy, you have a policy proposal, it goes through the political process. Here in the United States and many other countries, it's very similar. And then there's a lot of bargaining, there's a lot of negotiation, there is a bill, a final sort of way of dealing with this, and that gets sort of formalized and becomes law, and then that law becomes implemented. And for most of the environmental issues in the United States, the implementation results in the legislature saying, look, the executive branch, the agencies, and we have specialized agencies that have been created and now are somewhat longstanding in the United States at the federal level, but also within the states, the same things have happened within the states and the state laws that have been created to deal with the same kinds of problems. But let's just focus just on the federal level for a moment. We need to do something. We've passed a law to do it. Now get some experts together, have those experts coalesce. You have some funding mechanisms that we've passed. We've funded the creation of entities, these bodies, the Environmental Protection Agency, for example, and we'll fund it in order for it to figure out how best to solve this problem that we call an environmental problem, the air being too dirty. And again, when we think about this, we can also remember that we have to put on our lenses and say, usually these laws focus on human health as being the standard. So if you have dirty water that's, affecting some species that isn't really seen as important to humans because we don't fish for it, or, whatever it may be, it may be some kill off of some species. But that species isn't, we're not acknowledging a direct association, it's not maybe living in that world of direct economic benefit, then maybe we don't do anything. We don't care. It's like, oh, that's too bad, but it's not something that we need to do anything about. There's not something that's really heightened our focus and attention. But certainly if you have a situation where there's some serious direct threat to human health and it's obvious, then you have maybe the public's attention, and maybe then you get this sort of reactionary result. And as I've said before, it's important for us to remember that most environmental laws are a result of this, again, reactionary, after the fact. Something bad happens and then we create a law to try to remedy the bad thing that we already see through this kind of process of issue attention. However, there is maybe some examples of trying to be proactive, and maybe not the original law, maybe, but some amendments to laws, or some, some new evolutions of policy, some add-ons, maybe not brand new policy directions, but some, changes and alterations in existing policy directions. And maybe they're a little more proactive in nature, which is, hey, before we wait for a problem to occur, we're going to make sure that we don't allow that kind of, we can foresee that that's the sort of worst case scenario or a very bad outcome. So let's go ahead and engage in actions today and start some policy directions that will ensure, or, mostly ensure, high probability that that bad outcome will not result. And we can think about this in many contexts. And today, certainly what we choose to do or not do, for example, about climate change, about carbon, movements of carbon, what policy actions are we taking to try to prevent a worst case scenario? Or are we simply going to wait until those scenarios play themselves out and just kind of piecemeal react to it? But we can think in larger scale about that. We can sort of use this conceptual framework of a reactionary sort of approach to environmental law and policy, or a sort of proactive approach. But anyway, we've reviewed some of the policies that drive the creation of environmental law. And we've reviewed the concept of environmental law itself previously, and how those laws are created, what we call needs and sources. So do we need environmental law? How do we define the environment? So this has been, under the previous 2 video lectures, we discussed a lot of sort of the issues surrounding this. What is the environment? What approach do we take to thinking about the environment? If you remember or recall, if you can go into those videos if you haven't seen them, but if you've already reviewed the materials and certainly the videos, then you'll remember we talk a bit about we have a cartoon economist versus a cartoon ecologist sort of approach. And we look at the environment maybe through different lenses, whether through the economist lens or the ecologist lens, right? And, the economist lens certainly focuses on humans being at the center of, however we define the environment. And then, the environment is maybe defined from a natural science standpoint, an ecosystem standpoint, or maybe not. Maybe it's defined from a very much human-based standpoint. And we see that in environmental laws in the United States. We see where human health is the sort of highest priority. So environment for environment's sake doesn't really exist in many environmental laws as the primary objective. It's more of, well, what's happening and how does it affect human beings? And then that matters most. If there's an effect on other things, or if the environment is changing in some ways, or there might be some, what you might term normatively a negative effect on certain aspects of the environment. Well, but if it's not negative towards humans, then maybe it's not such a priority. Maybe it's not the thing that we really, and sometimes we see this in laws, what we call primary effects, secondary effects, and tertiary, or, so sort of creating a hierarchy list. And humans tend to be at the top of that list for most of the environmental laws that we have in the United States. And that would make sense based on what we just discussed about sort of the reactionary nature to many environmental laws being somewhat dependent on human existence. Although we have the Endangered Species Act, for example, and we have the Marine Mammal Protection Act in the United States. And those are 2 examples where laws have been created, mostly reactionary, of course, because in order for a species to be considered endangered or even threatened under the law, and even the genesis of that law really is a result on seeing that, oh no, we're killing, there are not many of these particular species left. And that was sort of the put on notice that we're having a cause and effect relationship, that things we're doing are affecting the welfare of certain species. And so maybe that should matter to us. But in those cases, certainly humans, it should matter to humans, again, from that ecosystem perspective, that, geez, these species may be, even though we don't use them directly, they may be important indicators for human well-being. So, the sort of canary in the coal mine, or what you call the sort of indicator species. So, geez, we really like things about that ecosystem. And if this species isn't doing well, that means that ecosystem's at risk. And if that ecosystem's at risk, then maybe human well-being in relationship to that ecosystem might be at risk. So humans are certainly always connected, human well-being, to most of these laws. But again, the Endangered Species Act and the Marine Mammal Protection Act certainly would identify, particularly maybe even the Marine Mammal Protection Act, because it doesn't necessarily require marine mammals to be endangered, at all. So that might be a good example of a law where we're taking actions where humans really aren't at the, the forefront of thought, or even the primary or even secondary considerations necessarily in all instances, but we're certainly probably within the universe there. So we can always think of that too. So what is the environment? And then once we have a sense of, okay, well, what is the environment relative to these laws? And it may vary, then how do we create these laws in the United States? Where does the source of power come from? That sort of thing. So that's what we've already covered in terms of understanding environmental law. And now, before we start exploring specific environmental laws in the United States, we should overview the different kinds of law generally we will be reviewing. We should have an overview of what are, and that's this section. How does the US system work, generally speaking, large scale view of US law here in terms of, what are they, federal, state, that sort of thing, what the different types of laws are. So what we call how to find the law. And that's what we're doing today. So in terms of how to find the law, generally speaking, there are two categories of law in the United States. There's statutory law, and we've talked about this, and it's created by a legislative body and it's codified. And we give examples of statutory law. We've talked about that I just did in terms of the Clean Water Act and Clean Air Act, or the Endangered Species Act, or the Marine Mammal Protection Act. So statutory law is the formalization of policy into a legislative act. And that act is some sort of bill that goes through a legislature, whether that's at the federal, state, or even local level, and it becomes legitimized through whatever process. Certainly at the federal level, it's the signing of that final passed by both chambers of commerce bill that then goes to the president of the United States and gets signed and formally becomes law during that signature. So those two branches of government, the legislature and the executive, Article 1, Article 2 of the United States Constitution, they come together and they formalize law. Many states, it's pretty much the same. It's almost a complete analog, where at the state legislature, usually it's a bicameral body. There's, their legislative process does the same thing. They have, whatever two separate bodies, maybe a Senate and a House in the state legislature, but they do the same thing. They pass a bill, then they send it to the governor, who's the head executive, like the president at the federal level, the governor of that state, who then signs it into law. And that's the same thing. In most states, it's pretty much the same, but that's statutory law, and it's created by a legislative body, officially codified. Common law is the uncodified principles of law from history and tradition. So in the United States, and certainly in environmental law, as we'll see as we start getting into these laws, these specific examples. So there's a world of statutory law and statutory environmental law that exists, and that exists at the federal level, at the state level, and even at the local level in ordinances. And we'll talk about that. It's just nomenclature, but it's effectively the same thing. So there is this world of environmental law. But they are, if we can think about this, they are not complete in their coverage. You can think about them as support pillars, maybe. So you think of these sort of support beams, right, that exist, and they help to support something, but there's a lot of space, whatever that something is, a roof, for example, there's a lot of space in between the beams. So if we thought of environmental laws like many of these support beams, they might be close together, there might be a bunch of them, but we can see that there's space in between these support structures. And that space is a whole area, let's say, just sort of in our sort of this example, that's a whole area of potential environmental law that is not covered by these statutes. These statutes do not cover whatever that space is. They only exist within those support beam structures, whatever that environmental law is. It's the extent of the purpose and intent of that law. So that in-between space is a lot of places where a lot of things can be done to harm our environment or help our environment, but relative to, again, harm and help, these are all normative terms because they have to be applied to something. So they're all conditional statements, and we always have to remember that. But just accepting those, the fact that they are conditional statements allow us to use the term so we can, have a sense here. But let's say that, there's all of this interstitial space that the statutory laws do not cover. And one of the questions is, well, is that just a free-for-all? Is that just a place where anything can happen since there's no statutory law that covers that particular area? And the answer is no, not necessarily, because we have this other law, this common law. And in the United States, there's effectively two, and there's probably more, but there's two large-scale, one really large-scale common law tradition. Most of our common law in the United States, we inherited from England. our sort of, because of the colonial sort of history of the United States, how the Western European settlement occurred, particularly from England, mostly you think of the New England and the settlements there, Plymouth Rock and, that sort of thing. And the early traditions of the English crown having sort of a monopoly and then applying effectively English common law traditions for the most part over the colonies. And then that, once there was independence in the Revolutionary War, we carried forward a lot of that tradition. And we should say that if we keep going back, much of that English common law tradition, it depends on the area of law, but much of it is derived from Roman law. Remember Rome, I'm talking about the Roman Empire, Rome way back then, maybe 2000, close to 2000 years ago, basically was encompassed what is, England or Britain today. And, Roman law traditions, a lot of common law traditions that England established was inherited from Roman law tradition. So we find this in our law today, in our common law tradition. So we have a mostly English common law tradition that is, again, itself derived from Roman common law tradition. And that's important to know. And then, the other side is there's the example like Louisiana, for example. You'll find some variants and differences in Louisiana law. And because Louisiana has a sort of a French connection before the Louisiana Purchase, there's some French sort of common law principles or French law principles that are not exactly the same as the sort of English or, English Roman common law traditions. That's a little bit different. But most of the time, that's when we talk about common law, we're talking about law that isn't put down through a legislative process, isn't the formal legitimization of policy, but has been widely accepted as sort of these traditions. And we'll get into examples of that, of what that common law means as we start moving through the specific environmental laws that we talk about. And in particular, you'll see usually for like pollution or, there's a common law doctrine of nuisance, for example, but there's also the one that you would know today, mostly, sometimes it's been codified, it's been put into statute. And that's important to note. Some of these common law traditions or common law principles have whether at the federal level, a Federal Torts Claim Act, I'm thinking of, for example, or even at the state level, some of these common law traditions have been formalized. But you've often think about this. I mean, so historical traditions of negligence, for example. What is negligence, right? It's, most of you have heard this, hey, somebody's been negligent, or, I don't know, motor vehicle accident, for example, the driver was driving negligently, or somebody, you think of these torts, we call them torts, sort of civil wrongs that occur in the whole world of torts. Torts is a whole subject onto its own in law school. And there's all kinds of things that you learn in torts. And mostly these types of things, battery, defamation, these are all things that derive from common law tradition. And some of them have now been codified, whether at the federal or state level, into law, official formal policy. And then that codification provides very specific, this is what it means to be this kind of, negligence is defined as this, and you must show these things, and damages are given to you as such as this, and they're limited by that. And there's, you can understand that the codification provides very specific rules as to, the sort of what it means to be this thing, whether it's, battery, assault, again, defamation. There's so many different things, but you think of these common law, they all derive from a common law tradition of fairness, of sort of allowing society to sort of, how do people get along, and how do we make sure that we ensure that people are doing the right things, or things that aren't interfering, with each other's, everybody's personal freedom ends at the tip of the nose of the next person, so how are we respecting each other's rights? What's the common good? And how do we protect individuals from unreasonable intrusions into their life? So we'll see that in things like pollution, for example, the idea that somebody is polluting. We have public controls, environmental laws against pollution, but we also have private controls, and most of those private controls come from the common law tradition, like nuisance, for example, when somebody's actions on their own private property are causing an unreasonable interference with the use and enjoyment of the other person, some neighbor's private property. Think of somebody burning tires on their property, for example. That might not be a good example because there's probably a local ordinance, a formalized policy statute that about burning rubber, and burning things like that on your property. But you can think of other things, noise and that sort of thing, where there hasn't been an ordinance or a law, statute. They're all pretty much the same thing, a formalized statutory law policy. That there's just a private remedy. So we'll get into examples of that. But those are the two categories of law in the United States, statutory law and common law. Statutory law, as I said, just as a review, it's passed by the legislature and usually implemented by the executive branch of government. And all of the different types of environmental laws, all that alphabet soup there, are examples: the Clean Air Act, the Clean Water Act, the National Environmental Policy Act, NEPA, the Endangered Species Act, and the Marine Mammal Protection Act. Common law is the law common to a shared culture and traditions. It's inherited from past traditions. For us in the United States, it's mostly from England via Roman law, but also others, the French Louisiana example I just explained. So those are the major areas if we're talking about categories of law in the United States. And I use categories in parentheses because we're just using that as a way to sort of talk about two different sort of categorical differences based on legislative formalization of policy versus non-legislative formalization of policy, non-formal policy, statutory versus common law. So in terms of statutory versus common law principles, in terms of statutory law, generally it's a representation of consensus on an environmental issue. The full policy cycle through legitimation, passing of a law by a legislative body, and signed and carried out by the executive. So one important way to think about statutory laws, like when we're talking about environmental law, that is a statutory law, Clean Water Act, Clean Air Act, all of that alphabet soup there. It's a representation of consensus on that issue. Like I said at the beginning, what we're talking about here is usually, for environmental law at least, a reactive policy. So some problem has existed and there's a consensus. The whole process of creating legislation is really a consensus building process. So there's a public issue attention cycle. There's an issue that's created out there. The water's on fire and we can't drink the water and we can't swim in that water in that lake anymore. What the heck is going on? So these industrial plants are throwing way too much terrible chemical waste into this water and it's causing a problem. Something must be done. The public is outraged. Think of Twitter outrage, for example, today. So there's an issue and now politicians take notice and the public takes notice and therefore they call for their politicians, their elected representatives, to take notice. So then that results in some sort of, like I said, negotiated process where you create legislation. And during that process, you build consensus. So you have this end result, which is a law that passes. And that law is really a result of that policy, that focus on that issue, and then let's do something about it. So that whole policymaking process through creating a law is really a consensus building exercise. So when we see statutory law, we say, look, whatever that's dealing with, we know at least at that time, and always remember that, so it has historical underpinnings, and there's all kinds of interesting things here from a policy standpoint in terms of analyzing existing laws. It's like, hey, the Clean Water Act, 1972, 1973, that's when it was passed. That's a long time ago, right? Now we're talking about 50 years effectively. So 50 years ago, there was consensus on this issue by people that were elected 50 years ago, by a public that existed 50 years ago. Is it the same today? Or do we have what I call path, and it's not what I call, but path dependence? Is it simply that once a law gets created and legitimized, there was so much effort put into it that it's unlikely, even if that law has a sunset clause, even if that law has to be changed over time or reaffirmed, over time? Is it just simply that, look, it's existed, it's created its own sort of bureaucracy, it has its own sort of tailwinds behind it to the point where it exists simply because it exists. It continues to exist. At the very least, regardless of getting into the sort of weeds or diving down the rabbit hole there, Alice, on that, what we can say for sure is that whatever happened 50 years ago to create it may not be the same type of thinking, thought process that exists today. So we have to know that there is some historical antecedent to that consensus. That consensus was a point in time, at least for the creation of this law/policy. And today is a different day. The people that exist today, their representation today, priorities, so on and so forth, right? So we always can keep that in mind. Even though a law exists, is on the books today, it doesn't mean that what was meant and intended and, and agreed upon as a consensus when the law was created is what is the same today, is what exists today. We should always think of that. But generally speaking, outside of that nuance, we can say that statutory law for sure represents a consensus on the issue, at the least at the time that the law was passed. And so for environmental law, specific laws generally dealing with specific problems in particular ways. So we have consensus. This is to say really those pillars. So we have these specific laws that are meant to deal with specific problems in a specific way. We have pillars. The Clean Water Act doesn't deal with all water issues, every conceivable water issue that we could think of, or all issues related to water that we can think of. The Clean Air Act, the same thing. The Endangered Species Act, the same thing. The Resource Conservation RCRA and Recovery Act, or the Toxic Substances Control Act, TSCA. None of these laws, right, cover the entire field of what you would imagine for the subject area that they're describing. Rather, they are much like that pillar. They cover whatever it is that we're talking about specifically within that pillar. And all of that interstitial area is open for debate. All of that places between the pillars, sometimes it's covered, some of it is covered by common law, but not all of it is covered by all law. There are just these areas where there is no legal remedy. There is no law, formalized law, statutory law, or common law that allows for or provides for redress for some wrong that either an individual or a group decides has occurred within that area. There are spaces between those pillars that neither the pillar, the statutory law, or the common law filling some of that space covers. There's still some open space where there is no law. They're sort of just open and void. Sometimes there is no legal remedy for an alleged wrong. And we always learn, that's day one of law school, that's just an understanding in the United States. And I'm sure that's the same for most countries. As far as common law, there's lots of environmental harm can occur that is not covered or does not trigger a remedy under statutory law. So this is the interstitial space in my example. And common law can provide a legal redress in areas where statutes are insufficient or do not exist. It can fill in gaps, but it does not fill in all gaps. I just want to make that point again clearly. It certainly does not fill in all gaps. And it is generally focused on specific instance of harm. One of the important differences is that when we talk about common law, usually it's, like I said, the neighbor example. Well, the neighbor has a problem with what the other neighbor is doing. So neighbor A is doing something on their property that is interfering with neighbor B's use of their property. And neighbor B, there may be no statute that protects them, but then they look to the common law, right? There's no pillar of protection, but there may be common law protections. And then, unfortunately, if there is no common law protection, then they're out of luck because there's nothing that exists. It's in that space where there is no legal remedy. But the neighbor is an individual, and they're looking for something that will help them if there is no statutory that will help them specifically themselves in the common law. And common law, usually the redress and the harm is individualized. And what I mean by that is statutes are generally programmatic in their approach. The air is bad for people in general. So this law is meant to protect the people writ large. Common law, this individual is claiming harm for something that happened to them individually. The harm could be happening to other neighbors, but the common law is used as a tool for that neighbor to address the harm to them specifically. So it's more individualized in its approach, which means if we're thinking about policy, statutory law works much better because it provides a programmatic approach to a problem. It's not individualized. Whereas common law is not so good. Maybe it's good for filling in some of the spaces, but it's not so good from a policy approach when we think about large-scale environmental problems. Common law is generally not a good way to redress large-scale environmental problems because it's so individualized. The role of judicial review. So now that we understand the different types of laws, we have statutory law and common law, generally speaking, we can look at the role of judicial review. So what does judicial review do? Well, the judiciary helps us understand what the law means in context. What I have over here is I have our good old, if you remember, our hierarchy of laws, and I overview of the hierarchy of law in our introductory materials, and I also then link to, I have a very more detailed video lecture of the hierarchy of laws itself. It's housed in the administrative law materials, so the playlist of administrative law, but you can find it in the video lectures to get more details. And I think I even have a link in the first or second introductory video here for environmental law to that hierarchy of laws video, so you can see it in more detail if you haven't or if you're interested. But so what is the role of judicial review? So we talked about the legislative, so we talked about Article 1 and Article 2. We know that under the United States, and again, let's just stick with the federal for our example here, is that Congress, the legislature, Article 1 of the US Constitution, there are 3 articles, right? Article 1, 2, and 3. Article 1 creates the legislature, Article 2 creates the executive, and Article 3 creates the judiciary. So that's the separation of powers doctrine in the United States, and that each branch, each of those 3 articles, we call those also branches of government, the legislature, the executive, and the judiciary. Each of those branches of government plays an equal role in carrying out the functions of government. Well, for environmental law purposes, we've already said that, hey, the legislature formalizes statutory law, it creates policy through legitimation. The executive is involved at the federal level in both the creation of that law, the president signs, and most importantly, almost always with the implementation of that law. The executive, the agencies that exist within the executive branch, like the Environmental Protection Agency at the United States federal level, is then empowered most of the time by those laws to then implement those laws. And they do this here by what's called the delegation doctrine. Usually those laws say, now go government, federal government, or a specific agency and create rules and regulations to implement this legislative will, make the air clean. And so they go about engaging in through administrative law principles, the development of regulations. Regulations are these other legal, they're not laws, they're not statutes, right? They're created by administrative agencies, but they're given the sort of legal effect of being like laws, quasi-laws. Everything in the administrative world is quasi, so they have these quasi legislative effect, and these rules must be within the boundaries of the law that created it, of course, and certainly that law must be within constitutional boundaries, and those regulations must also be within constitutional boundaries. And that's a whole world, the whole world of is what the agency is doing within its parameters. So if it's acting under the Clean Air Act's authority, because it always has to be acting under some legislative authority. So if the executive branch is doing things, trying to regulate people or entities or businesses in ways that aren't allowed by the Clean Air Act, but it's claiming that it's using the Clean Air Act as its authority to do what it's doing, then there can be a challenge in saying, look, that what you're doing is outside of the statutory delegation. You have no authority because the Clean Air Act did not grant you this authority. Also, looking one step above to understand this notion of a hierarchy is that the Clean Air Act, it's unusual that Congress passes laws that are unconstitutional, on their face at least. Sometimes the way that the law is being applied, there's another way. There's two types of constitutional challenges, right? There's, and we have it right here as a facial and as applied. Sometimes the law can be applied in a way that is unconstitutional. But the point is the Constitution sets the parameters of how far that law can go. The parameters relative to its effect on individuals, because the Constitution, effectively, at least the Bill of Rights of the US Constitution, in many of the amendments, protect individuals against government action. And so certainly laws have to be within those constitutional constraints, and the regulations have to be within both the law and, of course, within the constitutional restraint. So this is a nice way of just remembering that. So what is the judiciary's role? Their role is in determining whether or not the agency, aka the executive body, is acting within the statutory constraints created by the particular law and within constitutional boundaries, and certainly also within challenges to the statute that might be brought, making sure and making the judgment as to whether or not the statute is within constitutional boundaries, for example. So that's the role of the judiciary, is making sure that actions taken by government under some authority for some environmental purpose are legitimate. It's the simplest way of saying it, but it's very complicated. So the judiciary helps us understand what the law means in context. It tells us what the law actually is. It gives us judicial interpretation. It reads the statute. It clarifies what the statute is meant to mean in case there's ambiguity. Well, words by definition, right? Words by their very nature are ambiguous, subject to more than one meaning. So I can read a statute and say, well, it obviously means this. My interpretation is it means we can do this, or government is prevented from doing that, or individuals are prevented from doing this, or we're allowed to do this under this law. And another can read it and come to the opposite conclusion of everything that I just said and say, no, that says the other. So one thing that the court system does, the judiciary does in the United States, is tell us what is the reasonable objective interpretation? What is the plain meaning? And that's the first thing they search for. What is the plain meaning of that statutory language? What is it supposed to mean? And over time, they build through a number of court cases, mostly at the appellate level, but they build precedent. They build a series of cases that help the courts in general interpret what that plain meaning is. And there's a concept, not to get into too much of this because it gets into just too many far-field areas, but there's a concept in US law called stare decisis, which means that courts are bound by their own prior precedent. That when those mostly courts of appeal and higher decisions are made, that the courts must follow whatever those decisions say in their own interpretation, including trial courts, lower level courts, must certainly, and also appeal courts, including the United States Supreme Court, adhering to its own precedents, its own prior precedents, stare decisis, making sure that you're when you say something in a previous ruling, that you're following that same logic and you're following whatever that particular, conclusion is. Of course, we have to understand that many of these precedents are fact sensitive. They deal with the specific facts of that particular case, and every case has different facts. So even though there's a precedent that says that under these facts, this is generally what it means, when you have another case, you say, oh, those facts are similar, but there are key differences, and therefore that precedent doesn't apply here because these facts change the precedent. But the point is, there can be a lot of room for, there's an old concept, and it's true about human beings, and that's reasonable minds can differ. And so, you have different individuals, different sets of individuals making decisions about similar sets of fact, but yet still different, and they can come to different conclusions, reasonably can come to different conclusions. So we have a lot of variance in terms of how courts might interpret certain facts, but the judiciary's role in general is to help us understand what the law means. And they are bound within these sort of rules. What is the plain meaning? What's the precedent say? Stare decisis, they're bound by their own set of rules and that sort of thing, and many others that they apply to help them understand and interpret the law. So they help us as the third branch of government in understanding what the legislature and the executive is doing. And environmental situations, environmental law, that's certainly the case. So the statute sometimes might be in violation of minimum constitutional protections. Like I said, there's both facial challenges. The statute itself is unconstitutional as it's stated that, there's another rule of interpretation, and that is that the courts, when they review statutes and legislative enactments, their first and primary purpose is to read the law to be in conformance with other laws, including the Constitution. In other words, there's a tenet principle that they use, which is legislatures aren't in the business of passing laws that are on their face unconstitutional. Therefore, we will read the law and interpret it in a way that shows that it is not meant to violate constitutional protections. We assume the legislature did not intend to pass a law that was facially unconstitutional. But there's also as applied challenges. That's the most of it. That's like the law's fine, but it's being used by the executive agency to create rules that are unconstitutional, or under these facts, the law as applied to these facts is unconstitutional for one reason or another. So that's another way that they look at that's the as applied challenges. And those are mostly what we see. And then the legislature passes laws, executive implements, and the judiciary interprets. Another way of seeing the separation of power is just that. You have the legislature that passes law, the executive implements the law, and the judiciary interprets. That's our way of understanding the role of judicial review. Questions of jurisdiction, state and federal. So we can look at law and court systems. So now we have an understanding of, what types of law, statutory, common law, generally speaking, what's the role of the judiciary, and then questions of within the court system itself. How do the court systems work in the United States, laws and court systems? In terms of laws, state and federal laws are generally referred to as either statutes and codes. This is helpful because of the nomenclature. It's just to keep it clear. So if you're either it's in the materials, if you're here in environmental law and you want to know and understand a little more in detail, or if you're out in the world, you're just trying to understand different nomenclature, you hear different terms and trying to put them into perspective, or trying to understand what's the difference between a state court and a federal court, generally speaking, because this is all very detailed. So this is just a very superficial overview here. But in general, laws, state and federal, statutes and codes, usually hear those two terms. At the local level, local bodies, think of, municipalities, for example, right? Cities, that sort of thing, right? They'll have city councils maybe, and they'll pass laws, and their laws, their official formal policy statements are generally called ordinances, generally speaking. So you'll see these, city ordinances. But they're all formalized policy. They're all the same thing as laws, statutes, codes, ordinances. So the delegation, the statute, code, ordinance, implementation to the agency. And we've seen that delegation. So we understand that, there's this ongoing notion of delegation where these things, move towards an agency for implementation. So that's laws, nomenclature. In terms of court systems, federal courts, mostly federal courts deal with questions of federal law. Federal courts are courts of limited jurisdiction. You have to show standing, and there is limited, again, access to federal courts. You have to show a federal question, a violation of a federal law, for example, that sort of thing. It's not entirely easy or guaranteed or secure to get into a federal court. You certainly, for example, if you had a state law that you were trying to enforce in and of itself, just the state law itself, and you tried to go to federal court to enforce the state law, you would be denied jurisdiction generally, because the federal courts deal with federal questions, not state law questions solely. Sometimes there are situations where you have a cause of action where there's both a federal question and there's a state law. So there's a potential violation of federal law and a violation of state law within the same action. And sometimes the federal court will hear the state law case. This is questions of law, and this is about, there are other issues here in terms of the form, the correct form to bring a claim. But generally speaking, federal courts just hear federal questions. State courts mostly deal with questions of state law, but they are not. State courts are generally seen as plenary or general jurisdiction, sort of the opposite of the limited jurisdiction of federal courts. If you have a claim, and the claim is properly brought against a defendant in that state court venue, and they reside, that sort of thing. But if you have a claim and it's the proper jurisdiction exists within the physical space of that state court, then generally state courts have general jurisdiction over those issues. And that can include both state and federal law questions. But we do have federal courts and we have state courts in each state. And it's important to understand that that they both exist in the same areas, but they are different. And in terms of courts of appeal, both at the federal and state level, in the federal level, you have courts of appeal, COA, you have their own courts of appeal, and of course you have the US Supreme Court. And not only do you have courts of appeal, but then you have district courts. So the federal system has its own level of, sort of appeals. There's not just one level of appeal before the US Supreme Court. Generally, there's courts of appeal, and then there are, federal district courts of appeal that are sort of like the appeal for the appeal. And then there's, so it just depends. It depends on the court, and it depends on, you have to understand we have a lot of different types of courts in the federal system. Some of them are more administrative in nature. You think of immigration courts, for example, and then they have their own systems, but they are more in the administrative side of adjudication there, but then they can then move into federal court systems. It gets a bit complicated. So let's just say, again, for our general superficial overview here, we have federal courts, courts of appeal, US Supreme Court is the final say on issues as a court of appeal in the United States on all matters that it deals with. And that includes both federal questions, federal issues, and also potentially state questions. Certainly between states when there's problems of law or there's direct actions between states. The US Supreme Court might have original jurisdiction over actions between states, for example. This is all based on federalism. this agreement between federal court, our federal government being an umbrella over the state governments, which are their own sovereigns. And at the state level, we certainly have courts of appeal. We usually have state Supreme Courts, and all called Supreme Courts, just some different sort of nomenclature, but that's the highest courts of appeal in that particular state. And they're just like the US Supreme Court for that state. And they interpret state questions of law generally, but also can include federal questions, like I said, and specifically, say, US constitutional questions. So often state courts can hear US constitutional questions as part of a larger cause of action, because they are plenary courts or courts of general jurisdiction. So in terms of laws and court systems, some differentiation of the nomenclature and also at the different levels. In terms of final thoughts, in terms of how to find the law and overall speaking in this overall sort of introduction and overview of environmental law in 3 different sort of lectures here, we should have some knowledge of the following after taking in all of this information. We should definitely know the difference between statutory and common law. That's for sure, right? We already talked about, think of the pillar example and the space in between the pillars. Statutory law being those pillars, being the formalization of policy, applying to a wider area, sort of wider area protection, and informing the public about, important aspects of policy, that what the government cares about for all people in that particular area, whatever that area is, clean air, clean water, so on and so forth, to the degree that that statute covers a part of clean air or a part of clean water. Again, the Clean Air Act doesn't cover everything related to clean air. The Clean Water Act doesn't cover everything. They're pillars. There's a lot of space in between, but to the degree that it does cover it, it covers it for everyone. It's for the public well-being. Common law deals with that interstitial space, not all of it, between those pillars of statutory law, and is more individualized. It allows individuals to seek remedies on behalf of some harm towards them, generally speaking. The role of agencies is to develop and implement regulations. So we understand the difference between statutory and common law, and then we say the role of agencies, the executive branch, is to develop and implement regulations. And those regulations are directly related to that statutory law, usually, and that statutory law provides a delegation, either explicitly or implicitly. And then the court system, federal and state, know the difference between limited versus plenary jurisdiction, and also what does the federal system do? What does the court system do? I'm sorry, not the federal. What does the judicial system do in general? They look at what agencies do, they look at the statutes, they make sure that everything is in conformance. Think of the hierarchy of law. So they sort of are the courts that tell us what is the law, what does this law mean, and how does it apply in these particular instances, and is this action, this government action, within the confines of that law. So we should know that. And main points to remember as far as a bigger picture when we think about environmental law, based on what we've already discussed, sort of the larger policy perspective, is the law is really the outgrowth of policy development. That's really important to understand, particularly statutory law. Also common law, but it's much more historical. But statutory law is really the outgrowth of policy development, whether it's that issue attention, the law being reactive to things that are happening versus proactive, but also potentially proactive. It really talks to us. When we read laws, we should be able to sort of sit back and say, oh, this law says this, and that's important to know what it says. Why does it say what it says? And that's the bigger issue. Why is it talking about this in particular? Why is it defining the environment as this? Why is it defining protection of clean water through human health standards? Why isn't there some other standard that's being used? That helps us understand the larger policy picture, because the law is really the outgrowth of policy, not the other way around. And the law follows policy directions. That's another way of saying what we just said, right? Including environmental law. So often the laws that we read, particularly in the environment, and the laws that we understand exist, are the result of existing policy directions, policy responses to pre-existing things that have occurred, issue attention, that sort of thing. We should remember that. And also, the law has structure. So not only is the law an outgrowth of policy development, but it has structure. And that includes, for our purposes, and what we've already talked about, the hierarchy of laws and separation of powers. Really important to understand those two concepts. Hierarchy of laws as a way of trying to understand what that structure means relative to how government, writ large, those 3 branches of government, interact with one another. And then the separation of powers. Who does what? who interprets, who creates, who implements, what are the main functions of different parts of that government. So remembering those things really help us start to get a handle. We have a good conceptual framework of what environmental law is, and also our legal structures in the United States generally, but certainly what environmental law is, how it's created, how we can view it, and how we can really think about it in a larger context. That's all. Thank you so much.